Hello all, this video is going to go over the first two sections of chapter 15 since I will be away on the Model UN trip on Monday. Um, Obviously when I come back on Wednesday, feel free to ask questions about these sections, but these are relatively straightforward, and then I think the more meaty sections we will have an opportunity to go over as a class. This chapter is about the court systems. One of the things that the book introduces us to at the very beginning of the chapter is whether or not it's fair for the court to have a role in policy making. Because, ultimately you see that the president, the executive branch, and the legislative branch, of course, have more lawmaking abilities built into the Constitution. Of course, the legislative branch is the branch that actually makes bills into law, but also, of course, the president has the ability to sign them, veto them, and of course, the bureaucracies that often are controlled by the executive are implementing policies. But the court also, because of its judicial review process, certainly has the ability to shape policies, find something unconstitutional, and so on. And we have to address whether or not that's fair. And one of the reasons why we could argue that it's not is because justices are not elected, right? They're appointed. So could we say that this fact, the appointment of judges, does this undermine majority rule? Is this not fair? Especially because justices often, serve life terms or they retire at a very late age. Also, there are some people that think that the courts should have the ability to shape policymaking, and those who say that make the argument that the courts could protect minority rights. They don't have to be subject to the will of the people as much because they're not worrying about elections. And also they set very important historical precedents. A case that we'll bring up a lot this chapter is Brown versus Board. It was a case that wasn't particularly popular by many members of the general public, but at the same time it was a huge precedent for desegregating public schools, as you probably remember from US history last year. So anyway, let's get into the actual nature of the judicial system, uh, what types of cases go before the courts and so on. So one of the important things is that according to the way that courts are structured, an impartial judge should always be presiding over a case, right? The judge's job is to solve a dispute between two opposing points of view. So of course that implies that he needs to be impartial. Okay, the two most common types of cases that we'll be discussing are criminal and civil, right? Criminals, just like it sounds, right? It deals with someone who actually breaks the law, and they face certain punishments if they are convicted in court. Most of the time they could go to prison or they could pay a fine. Also, of course, probation, community service, or other types of sentences for criminal convictions. Civil cases. Now, when we think civil cases, we most often think of lawsuits, right? So, of course, it's still a dispute between two parties. In this instance, one party can be the government, so you could sue or bring some sort of case before the government. Oftentimes it deals with the violation of a contract. It could deal with an argument over property. It could deal with a dispute during a divorce proceeding. It could deal with an argument over child custody, damage to property, and so on. This is a kind of silly thing to say, but at the same time, if you ever are watching one of those silly court cases on court shows on TV like Judge Judy, it almost always deals with civil court cases, right? So when one sues one another, it has nothing to do with actually breaking a law. It could be something that you do that's legal, but at the same time, it arguably causes damage to one party who decides to bring it to court. Okay, so the different participants in the court system, right? First, the plaintiff. Think of the plaintiff as the accuser, the person who actually brings the case before the court, right? They are the person who charges the defendant of doing something that damages them. All right, a plaintiff can't just bring forth any case. He needs something called standing to sue. So in other words, he needs to prove that he is in danger or has already been injured by a certain party, right? So, ultimately, if there was some sort of property dispute case, the plaintiff would have to prove that the defendant already did something to hurt him in terms of the property that he owned, right? There might be a dispute over, some sort of border between properties, right? Maybe there was, a tree that arguably was on one person's property, but the other person in the case argued it was on his property. The defendant cut that tree down. The plaintiff said that was my tree. You had no right to cut it down. There you go. There's an example. All right. So if you are just opposed to a particular law, you can't sue. You can't just say, well, I don't think that's right. You actually have to prove that you were damaged or injured somehow. And of course, it could be financially injured, right? A class action suit, right? This kind of expands the scope of what a plaintiff can be, because in a class action suit, you can have many plaintiffs, right? Basically, it can be a group of people who are all affected by something who can bring a case to trial. All right. Popular forms of class action suits often have to do with environmental protection. So one example I think of, if you've seen the movie Erin Brockovich, you may remember that the case was actually about a number of people who lived in a rural California town who were all being exposed to pollution that actually was causing a number of forms of cancer. So ultimately, the people who were involved in the case were actually suing on behalf of many more people who were affected by this pollution, right? So in a class action suit, you can actually sue on behalf of other people who aren't even directly involved in the case. Okay, a defendant is a person who's actually charged, right? So the person who is sued, and they tend to not really want to be there, so they're the reluctant participants. I know that this is very silly, but this is the defendant here. He is very upset because he is in the case and he is arguing that he is not guilty, or he has not done whatever the plaintiff argues he has done. Other participants, it goes without saying, you have a jury, right? There are some cases where there is just a judge presiding, but many cases involve a jury, all right? You are probably very familiar with the fact that a jury just decides the outcome of a case. Of course, you also have attorneys, right? The people who are actually arguing on behalf of both the plaintiff and the defendant, all right? They're a very important part of the legal system, and now we know every time we watch any sort of crime show where someone has read their Miranda rights, everyone, regardless of income level, has the right to an attorney, right? However, you could argue there's still a discrepancy there because, of course, the very, very wealthy people are going to be able to afford a better quality lawyer, right? So there is certainly discrepancy there. Interest groups also have a prominent role in the court process, right? A lot of times interest groups will get involved in supporting or defending or supporting or opposing the litigant's involvement in a case, right? You see actually a very good example in history is that during the Brown versus Board case, the National Association for the Advancement of Colored People got very involved um, in influencing the Brown v. Board opinion, right? You also see the ACLU, the American Civil Liberties Union, often gets involved in cases that deal with civil rights. One of the major ways they do this is they file amicus briefs. We talked about this in a previous chapter, but remember that an amicus brief is otherwise known as a friend of the court brief. It is people that are not directly involved in the case, but they have a sincere interest in the outcome of a case. So they write a number of these briefs that are attempting to influence the court's opinion, right? So a lot of times there are amicus briefs that are filed over a particularly significant case, a case that could affect a large number of people. Roe v. Wade is a good example of this, all right? So if it's really significant to the public, if it's going to affect a lot of people, you could have a lot of amicus briefs that are filed. All right, so section 2, how are the federal courts structured? All right, one thing that's important is that the Constitution does not do anything about this. This is something that has come over time, right? We have a number of different courts. Starting in 1789, we started to work on court organization. Legislative courts. These tend to exist only for specialized purposes, right? And some of them are listed below, right? Military appeals, federal claims, international trade, and tax court. All right, unlike other courts, judges do not have judicial review. So in other words, they can't actually decide whether or not a law that might be covered during that case is unconstitutional. So ultimately, they're just kind of presiding over these cases, and they don't actually have a role in the constitutionality of a case. Okay, so so again, very, very specialized, specific purposes. Original jurisdiction, that is another word for say, or another phrase for saying that the cases start there, right? So, these courts are the first to hear a case They basically determine the facts of the case, right? What is involved, what is at stake, who is the plaintiff, who is the defendant, and 90% of all court cases originate uh, here, right? In these courts that have original jurisdiction. All right. Now, original jurisdiction doesn't necessarily mean that the case ends there, right? The court's decision can go to an appeal, which is where appellate jurisdiction comes into play. These are courts that can hear cases that were appealed to them by a lower court. All right. So basically, an appellate court could go even higher, right? After reviewing all the legislative issues involved in a case that goes before an appellate court, the case could be appealed to a high state court or even the Supreme Court. All right. District courts. Okay. The district courts deal with original jurisdiction. Okay, so they don't hear appeals. All right, so again, this is where cases start. There are 91 different district courts throughout the U.S. and its territories. And I wrote that the jurisdiction is listed in our notes. They have a lot of jurisdiction. They can deal with criminal cases, federal crimes, right? Oftentimes the person who enters this trial gets a plea bargain, right? So this basically means that a criminal might exchange information with prosecutors in order to get a lesser sentence. All right, so federal crimes, it's actually relatively rare for criminals to face a trial. All right, civil suits. Okay, so, basically, cases, we already talked about what a civil case is, right? These tend to be heard in state and local courts. It is also rare for civil suits to go to trial. Many of them settle out of court. You also have civil suits between citizens of different states, or maybe between a citizen and a foreign national. The amount of money in question for a civil suit here that goes to a district court has to go over $75,000, and this is designed to protect bias in state court in favor of the citizen from that state. You could have bankruptcy proceedings. You could have admiralty maritime cases, supervision of naturalization of aliens. All this stuff goes into the jurisdiction of district courts. All right, there are also many other members that are important for the district court system. You have bailiffs, clerks, magistrates. All of them help make sure that cases are conducted in a smooth way. Make sure that the defendants are properly handled. Make sure that the records of a case are actually recorded accurately. For every district, so for all 91 of these districts, there is a U.S. attorney, and what they do is they represent the U.S. government in civil cases. It's also important to realize that it's pretty easy to appeal cases that originate in district courts, that is. Everyone who requests an appeal will be granted one, but you have to pay the expense for that appeal. All right, next. The appellate courts, oh, sorry, that's the Supreme Court. The Court of Appeals, right? They hear the decisions of district courts, right? They can review and enforce orders of independent regulatory commissions. So that shows us that the court actually has some oversight over the bureaucracy. Almost all cases that go before the appeals court are coming from district courts. The Court of Appeals is divided into 12 judicial circuits. I'll show you a map of that in just a moment. All right, most of these cases are heard before 3 different judges, but in some very important cases, the judges all sit together, which is called en banc. The U.S. Court of Appeals is a special court of appeal. It hears appeals in very specialized cases such as patents, claims against the U.S. and international trade. So see how, these are issues that deal with the entire government, which is why there's a separate U.S. Court of Appeals. You can't do this in a state appellate court, right? If it's a claim against the U.S., it deals with the entire country. It's meant to correct any errors that occur in earlier case proceedings, right? So they don't conduct actual trials or testimonies. Rather, they're just seeing what may or may not have gone wrong in the district court. Okay, and whatever decision they make sets the precedent for the entire jurisdiction. Again, here's a map of all the appeals court circuits throughout the country. All right, also shows the territories. It corresponds with the color, right? So you have Puerto Rico joining District 1. You have these areas here in the Caribbean, these Virgin Islands. It's kind of cut off, but the Virgin Islands go into this jurisdiction, 11, and you don't see 12 because that is DC separately. On to the Supreme Court.